Let's go on the record on cause number DC 199701, Vanita Cole versus Danae Jackson. Counsel, make your appearances.
Rachel Hatton-Adam, counsel for both plaintiffs, Van and Vanita Cole.
And Anthony Lascalia, attorney for the defendants, Danae Jackson.
We're on a motion to strike. Let's go ahead and proceed.
Yes, Your Honor. We are here on the defendant's second motion to strike, the controverting affidavit specifically only towards plaintiff Vanita Cole's treatment at Epic Pain Center. For a brief background and context, Your Honor, this is, as I said, the second motion to strike. Back in October of last year, we held the motion to strike the controverting affidavit of the same counter-affiant as to the treatment and specifically the billing at Epic for plaintiff Vanita Cole. At that hearing, it was on October 19th, Your Honor granted our motion to strike and denied defendant's request for leave to amend. Subsequent to that hearing, and in the interim between our filing that motion to strike and having had the hearing set, we had served on October 6th, so just a few weeks before that hearing, subsequent and updated billing affidavits of additional treatment. At issue, the only thing that has changed between our original motion to strike that was granted and now defendant's second motion to strike from the same counter-affiant of the same medical provider is one date of service. One date of service for a charge of $742.50. This is the same charge for like dates of follow-up service that were already discussed and argued at our first motion to strike. Today we are here because at our follow-up, our second motion to strike hearing, that was back on January 4th of this year, Your Honor had requested briefing on this unique issue, which is, in essence, do defendants get a second bite at the apple of all of the charges and services that were included in our originally litigated and argued motion to strike, all for one updated date of service. And Your Honor, it's our position that they do not. There is no case law to support defendants' new second bite at the apple, so to say, at seeking to controvert the reasonableness of all of plaintiff's medical charges, when the only thing that has differed from Your Honor's initial assessment of the same counter-affiant's controverting affidavit and his second one is one date of service. It goes against policy, Your Honor, and I believe you have before you both defense counsels as well as our briefing on this issue. Because this is a unique issue, I'm not sure what Your Honor would like me to expand upon, although I'm happy to expand upon either issues in the counter affidavit or the policy issues.
Response.
Judge, yes, on October 6th of 2020, the plaintiff filed a new affidavit in the amount of $25,752.66. 3 weeks later, within that time, within that 30 days, we filed a controverting affidavit up to that amount. The amount filed on their October 6, 2020 affidavit in the amount of $25,750.66. The plaintiffs made the argument that they weren't the ones that provided that affidavit, but they're the ones that filed it. They essentially provided a new affidavit in the amount of $25,752.66, and we have the right to controvert that amount, up to that amount of their October 6, 2020 affidavit. That prior motion to strike was for a different affidavit filed before that October 6, 2022 affidavit. This is essentially a new affidavit. There's been no objection to timeliness. There's been no objection to qualifications to the affidavit. We also provided some.
Let me ask this. So there was the first, I remember this happening because it was such an unusual situation. The second counter affidavit, is it essentially the same as the first counter affidavit?
Yes, but for one charge. Oh, I apologize.
No, I mean the counter affidavit.
The counter affidavit, I believe there was a defect in form in that first affidavit, and that has since been corrected in this.
What was the defect in form?
That although our doctor provides treatment in Dallas County and he resides in Dallas County, he did not put in Dallas County in his affidavit. In that other affidavit for this new treatment, he did put that he practices law, or sorry, the treatment was unreasonable and unnecessary in Dallas County and surrounding counties. And that is addressed in his affidavit controverting the affidavit that was filed on October 6th of 2020. And we did file that within 3 weeks after October 6th of 2020. And we believe that that new affidavit supersedes the previous affidavit, and we have the right to controvert the amount in that October 6th, 2020 affidavit. And there has been no objections to qualifications or timeliness of that controverting affidavit or counter affidavit.
A response?
A response, yes. First, let's address the, to piggyback on what defense counsel's last point was, which was the cure that was made was just to where the counter affiant practiced. That was not the basis of our original controverting affidavit, Your Honor. I believe that was not the basis of Your Honor's opinion or order striking the counter affidavit. The deficiency in the counter affidavit, both of them, quite frankly, is that it does not give reasonable notice as to the basis of how this counter affiant has formed his opinion. There's no methodology as to his purported sources that he may or may not cite. We don't know how he's using these sources. And so there are for a number.
Is this the counter affidavit we're talking about?
Is it the one that was filed?
October 28th?
Yes, that is the counter affidavit that is currently at issue.
Okay. And this is the entire counter affidavit?
That's not that's the affidavit form. There should be a few more pages to it of the treatment. There's an exhibit. Yes, so he does address.
Oh, is that it? Okay.
But then the first 2 pages are.
Go ahead.
Yes, Your Honor. As you'll see upon review of this subsequent counter affidavit, which again is the second bite at the apple, and I will get to that point at the conclusion of my response, you'll still find that it is deficient in failing to provide reasonable notice as to the basis and how that counter affiant has formed his opinion as to what constitutes a reasonable charge and why that is the reasonable charge in the same geographical area for the same or similar services. So that has always been lacking. It's still lacking and still does not meet the higher 18001F standards nor the requirements of Turner and its progeny. Moving on to the policy argument, Your Honor, if you take defense counsel's statement, which is, well, they filed a second affidavit, therefore we get to controvert it all, that cuts against, it is a waste of the court's time, resources. It's a waste of litigants' time and resources. It cuts against the whole purpose of 18001, and that it is punishing, it's punitive as to.
Let's kind of talk through. Let's talk through this. So let's talk about practically. Let's say I deny your motion to strike their counter affidavit. Doesn't that just knock out the amended affidavit? You could still use the original affidavit with the one less treatment. Isn't that right?
Absolutely, Your Honor. However, at that point, then plaintiffs would either be forced to use only that affidavit and therefore not present to the jury the full scope of our plaintiff's damages, or call her treater.
You're only talking about one visit, correct?
Yes.
You lose one visit.
Yes. Although practically my concern would be what if there had been other than one visit. But for this case, yes, Your Honor, it is that.
And you want to have this, it seems like an awful lot to fight over for one visit.
Correct. For this case, absolutely, it's our position that everything, now this is the third hearing on this issue, all for one visit, because of the defense attempts to controvert now everything in retrospect, hoping that they get a full second bite of the apple purely because my client continued to treat.
And Judge, we have a response.
Sure.
We also provided some case law from the Court of Appeals that shows the issues with multiple and duplicative affidavit and the risk it is to the jury. In the case Katie Springs versus Favalora, and that was addressed in our brief of how the implication is that with multiple affidavits and duplicate affidavits, you run the erroneous and harmful verdict that the jury doesn't always set it out, that the jury can't always come up with a calculation. So they're relying on multiple affidavits for the same visit in multiple affidavits. So we believe that this new affidavit supersedes prior affidavits.
That was distinguished in our response.
I guess my thought is if we struck this most recent affidavit, you would go back to the previous affidavit, which was not struck, and then you would just submit that one. If I don't strike, if I do strike it, then the new affidavit would take the place of the first affidavit. Am I misunderstanding this?
No, I don't believe so. Just to reiterate, so we can make sure that I'm clear with the court. If this motion to strike the second controverting affidavit is granted, then there is no risk of our original, and by the way, this is our fourth supplemental counter affidavit. Defense didn't choose to controvert the first or the second, they chose to controvert our third and our fourth. If this present motion to strike defense current controverting affidavit is struck, then the only thing that will be before the jury is the most recent and the live, the current counter affidavit, which is dated August, I think, 1st or 6th of 2020.
Judge, procedurally, we timely filed this affidavit within 3 weeks, and our expert does walk through the charges as being unreasonable, and that he's familiar with customary charges in Dallas County and surrounding counties. And the initial same affidavit was found to be fine in Moyes court, and that was discussed at that first hearing. In this second affidavit, attacking these charges on that October 6th of 2020 affidavit, he does say that he is familiar with charges customary in Dallas and surrounding counties. And he does provide some literature on how he, not only from his own private practice in Dallas County, but some literature on how he determines those prices. And he does address that in his affidavit. In this same affidavit was found just fine, as I mentioned, in Judge Moyes court, as we put in our original controverting affidavit. But we do feel like procedurally we have timely filed this affidavit following the October 6, 2020 affidavit, and we are entitled to controvert up to that amount in that October 6 of 2020 affidavit.
Your Honor, if I may just raise a policy concern for consideration.
Go ahead.
Okay, yes. Defense counsel continues to say procedurally they're allowed to, procedurally they're allowed to. Let's hear that. 18001F, if there is a proper counter affidavit before the court that either we choose not to move to strike or the court denies our motion to strike, that is how the defense counsel could controvert the reasonableness and the necessity of the treatment at trial. If you take defense counsel's argument as posed, then despite the fact that we have successfully, and the court has found the same counter affiant's prior controverting affidavit, which really is not that different at all, except maybe his assertion that he said he also practices in Dallas, then now defense counsel in all cases would get to open up and the floodgates and have a full second bite at the apple, as it goes against the whole policy and cost saving mechanism before the court, as to allow them to attack now not just the only treatment that is different as to the reasonableness and necessity of that one visit that is different, but now the reasonableness and necessity of all treatment that this plaintiff has received in the past. And it's only because this plaintiff just happened to be hurt enough to continue to need additional treatment that they get the second, third. You could extrapolate how many bites at the apple they might get.
What if you had a situation like this? Let's say somebody went in and you're trying to argue that they shouldn't be able to counter the second affidavit, but let's say it was the opposite and the first affidavit just had the first treatment in it, and then the second affidavit had an additional 50 treatments. Should they be able to counter the additional 50 if they decided not to counter the one treatment?
By that argument, I would think that in this thought process, it would be right? They had their chance to controvert the reasonableness and necessity of that first treatment that they either chose not to, or it was stricken. And then any new treatment would be different. Would
And
be
they
up
would be
for
able to counter
controversy.
those or not counter those. What is your argument?
They would be able to controvert them, but not looking back and controvert treatment that had already been discussed and in essence litigated on that one issue before the court. Because if you
All
think
right, so what I'm going to do here, this has been going on long enough. This is just an unusual situation, and I'm not,
Judge, we have one more response. I'll be brief.
Okay.
In any other case, if a plaintiff attorney files a new affidavit, we have to file a new controverting affidavit with that amount. If we don't, that new treatment is not controverted. Some attorneys even say that that new affidavit is not controverted at all, and that supersedes. In this case, on the October 6, 2020 affidavit was for the amount of $25,752. We have the right to controvert that amount in the affidavit within 30 days.
Okay. All right. So what I'm going to do is I'm going to deny the motion to controvert the second controverting affidavit. So that means that the second affidavit, you would, if you want to try to get in that treatment, you would need to call the doctor live. So, but if you just want to get in the treatment from the first affidavit where I denied the motion, the controverting affidavit, then you can allow that entire treatment in through affidavit. Does that make sense?
that does, and yes, I believe that makes sense. I just wanted to make sure.
So that if you wanted to bring in, you'd have to call a doctor to get the new treatment in. You do not need to call a doctor for the original treatment.
Yes, Your Honor.
So basically, the second affidavit goes away. First affidavit is still live.
And for clarity, because this was the affidavit and counter affidavit at issue today was technically included in plaintiff's third supplemental notice of controverting affidavit. For clarification, any affidavit that was part of our first motion to strike, that is still
Good.
That's good. Okay.
So Ms. Hatton, why don't you go ahead and prepare an order to this effect? Because I know it's probably not what's in your original order.
Correct.
Run it by your opposing counsel and we'll go from there. Just get it, go ahead and email my court coordinator as well as e-file the order. And when you do the order, make sure you include the date of this hearing and the procedures that went into making this decision. So on such and such day, we had this hearing. On such and such date, we had this hearing. On such and, you know what I'm saying?
Mm-hmm.
So that it's clear what we've exactly done here.
Sure. Yes, Your Honor. The whole procedural posture on it.
Procedural posture, exactly. And then include that in the order and make sure you email my court coordinator all that.
Yes, Your Honor.
Anything else, guys?
That is it. Thanks, Judge. Thanks, Rachel. And
Thank you.
Rachel, will you email me the order before you file it?
Yeah. Oh, absolutely. Because it'll need your signature as to form at least.
The same page there. Okay.
Yes.
But make sure that you get this to me by Friday, okay?
Yes, Your Honor.
Right.
Thank you. You guys be safe.
Bye.
All right, let's go to Brandy Harris versus SB Premium. Both sides here on that?
Yes, good morning, Your Honor. Matthew Brining on behalf of plaintiff, and I have my co-counsel here, Ms. Arledge.
Your Honor.
Hello.
Your Honor, Robert Bogdanovich on behalf of the defendants SB Premium and Triton Distribution. I do not know, I can't see on my phone, unfortunately I'm a remote, whether or not Miss Kathleen Cruz is attending as well, but
she is.
She may be.
Your Honor.
All right.
All right, let's go on the record on cause number DC 1900359, Brandy Harris versus SB Premium LLC. Counsel, make your appearances.
Matthew Brining on behalf of plaintiff.
Natalie Arledge on behalf of plaintiff.
Robert Bogdanovich on behalf of Wages and White Lion Distribution, Wages and White Lion Investments LLC, doing business as Triton Distribution.
Kathleen Cruz on behalf of defendants Tiffany and Larry Scott Gresham and SB Premium LLC.
All right, we have a fairly limited motion here today. As I understand, it's a motion to strike the amended petition.
Yes, Your
Yes.
Honor.
Go ahead.
Yes, Your Honor. This motion was filed jointly by the Suicide Bunny defendants as well as Triton Distribution. The court should strike the plaintiff's first amended petition because this is a 13th hour amendment to a case that's been on file for 2 years, which completely changes the basis of the case. And the quickest analogy I can come up with is we're dealing with a product liability case that has to do with a vehicle. And I've alleged the entire case that it's the glazing on the windows. But now, based on certain circumstances, which I'll get to in a moment, I'm going to claim it's the A and the B pillars that caused that defect, et cetera, and the damages. This case was on file January 8th of 19, Your Honor. Since then, they have maintained that the flavorings in these vape juices is what caused Mr. Harris's mouth cancer. We had a scheduling order in place for the first trial setting in August of 19, setting trial in September of 20. It was Your Honor's standard form with the deadlines for amending pleadings, et cetera, initial trial setting, 120 days for amended pleadings, 45 days for other amended pleadings, et cetera. Obviously, we did not go to trial. But when we did not go, we set a new scheduling order in place for the February trial setting that is not going forward, or did not, Your Honor. And in that, it was our agreed order that we were amending only certain deadlines: expert discovery, expert motion practice, MSJs, mediation. And that's what we did. We worked together, we got that done. We spent the entirety of September, October, November, and December finishing all of the expert discovery. Their experts, our experts. And then summary judgments are reset for late January 2021. On the 15th of January 2021, the briefing is due in response to the summary judgments. We file ours, they file theirs. Saturday at 12:05 a.m., they amend their petition for the first time in 2 years without leave of court, completely changing the basis of their case, which through their petition and discovery has been the flavorings in these e-liquids is what caused Mr. Harris's mouth cancer. Now it's propylene glycol and vegetable glycerin. That's what caused Mr. Harris's mouth cancer. We're at the point where we have litigated this case for 2 years. They have had ample opportunity.
Let me ask you this. So for the depositions, what have the doctors and experts been saying, and expert reports and the disclosures been saying is the cause of the experts have been saying it's the flavoring?
Well, actually, Your Honor, so they have maintained in their pleadings and discovery written responses that it's the flavorings. Now, when it comes to experts, though, and I think this is where they're going to go with this, is why I made the analogy. Propylene glycol, vegetable glycerin are ingredients in vape juices, including these. No expert has opined or said that that is what caused Mr. Harris's cancer. Even with their recent filing on Friday, they tried to file a declaration from their sole testifying expert, Dr. Ongeko, saying the articles I reviewed in reliance for my opinion, my expert report, I reviewed those and I relied upon them to come to my conclusions. First, that should be struck and not considered by the court because it wasn't filed timely. But it's irrelevant because his opinion isn't even that propylene glycol and vegetable glycerin, these ingredients, caused Mr. Harris's mouth cancer. It's this, like I said earlier with my analogy, we're talking about e-liquid. So if we're talking about e-liquid and we've talked about these ingredients and we all know that they're in there, that can be the cause of his cancer. We have focused this entire case on the fact that they've made a specific allegation about the flavorings. We even specifically identified that as one of the ingredients. Generally, in the vape juices, there's nicotine, propylene glycol, vegetable glycerin, and flavorings, which they reference in their response. Now they're trying to change everything entirely at the 13th hour and say, we're going to change our story and completely undend everything we've worked to do. We've mediated this case. Your Honor knows that we just had a motion to strike the experts on both sides. And now, just because of COVID-19 and the delay in the trial, it's okay for them to completely, potentially reopen discovery, fact and expert, just because they realized, so it seems from the timing of the filings, that we need to change our perspective. And this is not just, again, it's about a vehicle, so it's a products case. They have to allege the specificity of it, which they did, and now they're trying to change it entirely, which will completely undend everything we've done.
Okay, response?
Your Honor, this case is now set for trial March 29th, 2021. And so the argument that the defendants are unfairly prejudiced by the amendment to our petition is moot at this point. The plaintiffs originally did plead that it was the flavorings that caused the cancer, but the basic premise of plaintiff's claim this entire case has been that the e-liquid is defective. When the e-liquid is heated, it releases these toxic chemicals that cause cancer. Now, plaintiff amended the petition to include flavorings, propylene glycol, and vegetable glycerin as the ingredients that release these toxic chemicals. It's not a change in the nature of the claim. It's not a change in the defect that we're claiming. The claim is that the ingredients that are inside the e-liquid are defective because when heated, they release these toxic chemicals that cause the cancer. Now, the defense doctor, she did testify that she didn't know what the ingredients in the vape juice were, and it didn't matter what the ingredients were because regardless, her testimony is that there's no evidence that any of the ingredients in the e-liquid release these toxic chemicals and cause cancer. And so the argument that there's going to be new experts and things like that, it's not accurate. And so we would ask the court to deny their motion to strike our first amended petition.
What was the change then between the first and the second, between the original and the first amended petition?
In the original petition, it's alleged plaintiff is alleging that the flavorings cause the cancer. And in our amended petition, we said the flavorings, propylene glycol and vegetable glycerin cause the cancer. And maybe that's an inarticulate way of putting it because really what it is, it's not that specific ingredient. It's when those ingredients are heated and the aerosol that the person inhales is what contains the toxic chemicals that cause the cancer.
And so the discovery, I guess what my concern is that I'm pretty liberal about granting motions for leave. What it concerns me is the situations where there's already been discovery that's taken place and then the other side has relied on the allegations and the pleadings or the discovery, and then they would have to redo them if leave was granted. And so that's what I guess my concern is here.
Well, I don't think the defendants articulated exactly what would be different about the discovery or the experts that they would hire, because the premise has remained the same, that the aerosol is what the toxic chemicals in the aerosol when inhaled is what causes the cancer. Again, their expert has testified it doesn't matter what we say, which ingredient we point to, because there's no evidence that any of these ingredients cause cancer or when heated create the toxic chemicals. And so really there's no other discovery or expert testimony that they've articulated would be different in order to respond to this pleading.
Response?
Yes, Your Honor. The flavorings themselves, they're not even saying that there's propylene glycol or vegetable glycerin in those ingredients, in the flavorings themselves. We've based our entire case on this through discovery, and it's incorrect to say that we wouldn't need extra experts, additional consulting with our existing experts to see if they were qualified to talk about the fact that now they are saying, whether in conjunction or not, that it's not the flavorings, which we're not even getting into what's in the flavorings at this point. It's now we're saying these two other ingredients that we have identified do exist and are in the vape juices. Now we're saying those separately can cause the cancer. They've talked about this, but none of our experts have dealt with this or testified as to whether or not, and I don't even know as I sit here, whether or not our experts are even qualified to testify as to whether or not propylene glycol and or vegetable glycerin are cancer-causing agents. It really re-opens everything.
Ms. Arledge is saying that your expert testified that she looked at all of the chemicals and none of the chemicals would cause cancer. Is that accurate or not?
No, Your Honor. What her testimony is that there are no scientific studies concluded or are reliable enough to say that vaping, and if you want to say generally, that e-liquids are linked to causing mouth cancer. There is no specific question, answer, or conclusion that she has made, Dr. Maddle, that vegetable glycerin and or propylene glycol, when utilized in a vaping device, if you will, cause cancer or do not cause cancer. So it's a little bit of a different position. And so right now what we're looking at is if the court was inclined to permit them to do this right now without leave of court, which they should have asked for regardless. But if they do this, I'd be in a position where malpractice, I have to go back and look at experts, possibly get other experts, look back at what we've questioned their experts on, because we haven't talked about this. It's been mentioned. The mere fact that propylene glycol and vegetable glycerin have come up in expert and fact discovery doesn't mean that you have a products case based on that's what you're claiming caused the injury to the plaintiff. And so since, again, we're talking about a car, it's defective. You can't just say the car is defective. What about the car is defective? They've changed that. And so again, if the court was inclined to grant this, I would say and ask that at the very least, if we have to reopen fact discovery, if we have to reopen and deal with experts, et cetera, that the plaintiffs be forced and be made to pay for the cost, expenses, and fees incurred with that at the very least, because that would make it fair. Otherwise, we're going to be spending hundreds of thousands of more dollars and thousands of hours of time dealing with something that we tried to wrap up, and we did by accommodating plaintiffs with their expert schedules, making sure everything was done in line with the court's trial date before all this happened. We've mediated. We've had experts motion practice already with the hearings, and now they just want to open it back up. I don't want to do that either, but my clients are going to be prejudiced by the fact that they did this 2 years after they filed this lawsuit.
But why was this? Why was there this amendment, Ms. Arledge?
The amendment was really primarily to remove our manufacturing defect claim in response to the motion for summary judgment, so that we didn't have to respond to that portion. I added in the additional ingredients to conform to the evidence that we had already developed throughout this case. I wanted to point out to the court that Dr. Maddle, in her report on page 3, she says that the main components
How do you spell Maddle?
M-A-D-L.
And who is Dr. Maddle?
Dr. Maddle is the defendant's retained expert who is testifying about that there isn't evidence or there isn't scientific research or studies enough to support that e-cigarettes and e-liquids cause cancer. So she puts in her report, though, that the main components of e-cigarette liquid, including nicotine, propylene glycol, and vegetable glycerin, are negative for genotoxicity and mutagenicity. And I can spell those if the court reporter needs. Basically saying that all of the ingredients are negative for causing cancer. And so this isn't something that has just popped up all of a sudden out of nowhere. This is something that's been addressed by our experts. It's been addressed in our response to the motion for summary judgment initially back in 2019, where we put in the very beginning that we are alleging that the ingredients that when they're heated up inside the e-liquid, it creates.
Have you, let me ask this, I don't think you have, but have you sued the individual component manufacturers, for example, who manufactured the flavoring, who manufactured the vegetable, what's it called, glycine?
Glycerin.
We have not. Okay. I guess the better, I appreciate the argument about the car. I guess I see this more like if there was an argument that Coca-Cola causes cancer and someone sued Coca-Cola and Coca-Cola's defense was, the plaintiff was arguing, well, Coca-Cola flavoring caused cancer. And then the defendant says, no, nothing about Coca-Cola causes cancer. And then the plaintiff comes back and says, well, it's not just the flavoring, but also, I don't have a can of Coke in front of me. The other ingredients, the fructose or whatever that caused the cancer. I don't know if you're not suing the individual components. I'm not sure that it really matters. I will say that if you insist on this amendment going forward, I would probably allow the defendants to amend their expert reports and discovery if in response, they don't have wholesale ability to redo things, but to respond to what you've just done, they will be able to respond to it. Does that make sense?
It does make sense, Your Honor. And frankly, after I received this motion to strike, I agree with you. I don't think the individual components are necessarily important, especially with regard to the pleading. I wish I had just pled that when the ingredients are heated, that it releases toxic chemicals that cause cancer. But I agree with you that the individual components aren't necessarily the important piece of this case.
Okay, well, give me an order on this that details that makes it clear that the defendants have the or this defendant has the opportunity to conduct additional discovery and pleadings to counter this if necessary. I'm not really sure that it is going to be necessary, but if it's necessary, they'll have the opportunity. I'm not going to require the plaintiff to pay for it. Okay, anything else, guys?
No, Your Honor.
No, Your Honor.
Thank you, Your Honor.
Just get me an order. Oh, did someone say something? No, okay, I thought somebody wanted to say something. Okay. All right, guys, just get me an order, and I guess we have our bigger hearing next Monday, right? Or this Friday?
Yes, Your Honor.
Friday.
This Friday, okay. All right, good to see you guys.
Thanks, Judge.
Thank you, Your Honor.
All right, Tony, it's going to be a busy day tomorrow. You may have to work a full day on a Tuesday, so we'll deal with that.